As I mentioned earlier, the court has had the opportunity to read the letters, and I listened carefully for those who spoke on behalf of Mr. Cooper, as well as those who spoke for Elijah McClain. The matter comes before the court for sentencing in this matter, as Mr. Cooper was convicted of the offense of criminally negligent homicide, a Class 5 felony in the state of Colorado, pursuant to 18.3.105 of the Colorado Revised Statutes. The court may impose a sentence anywhere between probation or a sentence of 1 to 3 years in the Department of Corrections, followed by a 2-year period of parole. The court mentioned this at another sentencing hearing, but I think it was mentioned here during the sentencing arguments that criminally negligent homicide is not considered a crime of violence by the Department of Corrections. So the truth in sentencing is that one who goes to the Department of Corrections is eligible for parole after serving approximately 37% of that sentence, and eligible for a sentence to a community-based sentence even sooner. So, and the court has taken all that into consideration. Mr. Cooper, you have 49 days within which to appeal your conviction. If sentenced to incarceration, you have 126 days within which to request a modification of your sentence. You do have the right to be represented by counsel for the purposes of your appeal, and if you were found to be indigent, the court could appoint counsel to represent you in that appeal. I don't intend to reiterate the evidence that was presented at the trial. Suffice it to say that the body cam videos were painful to watch. And here, the court doesn't find, and the jury didn't find from the evidence that Mr. Cooper purposely gave Elijah McClain the overdose of ketamine. I think the way that Mr. Slaughter has characterized it is indifference. The court sees it based upon the verdict of the jury as negligence. Certainly, Mr. Cooper injected Elijah McClain with an amount of ketamine that was more than the protocols called for a person of Elijah McClain's size and weight. What was clear from the body camera videos was that Elijah McClain was in an acute medical condition prior to the injection. And as was mentioned, the life of Elijah McClain mattered and matters. It's almost unthinkable the way things rolled out is the facts and circumstances in this case. And I've tried to put some sort of label on it, and I'm unable to do so other than I watched this movie a long time ago called The Butterfly Effect, and it starts with the contact with Aurora police officers, and things, rather than getting more calm or better, just seem to get worse every moment for Elijah McClain. The court also notes the somber reality, unfortunately, that there was no effective protocol, at least none that were used with respect to the transfer of command, in this case, between law enforcement and the medical personnel in situations like this. And as a human being, certainly, I understand Ms. McClain's words, which he says, you know, we've got protocols, we've got policies, and we've got rules, but we also should hopefully, in situations, in dire situations, indulge in our the best agents of our nature, our human instincts to help people. Certainly, Mr. Cooper was at the scene for a sufficient amount of time to have intervened. Yet he was in a situation, and the court notes there was some oversight, certainly, but part of the testimony, even from the expert witnesses, indicated that they have to rely upon the information that they get once they arrive on scene. And I'm not saying that Mr. Cooper wasn't on the scene for a somewhat significant amount of time, but there were a number of things that occurred prior to his arrival that were significant. He was in a situation where he was obliged to rely upon the information relayed to him by really the only witnesses that were there, and those were the law enforcement personnel. And that information that was relayed was clearly deficient. The court has to look at the nature and the elements of the offense. The court notes that the jury verdict did not reflect that Mr. Cooper's actions were performed after deliberation, intentionally, knowingly, or even recklessly. The verdict reflects the jury found that Mr. Cooper failed to perceive the substantial and unjustifiable risk that Elijah McClain would die, and in doing so, grossly deviated from the standard of care that any person would employ in this situation. The character and rehabilitative potential of the offender. Here, based upon what I've heard today from the friends and family of Mr. Cooper, and again, there were scores of letters, I have no doubt that Mr. Cooper's general character is of a good quality. The court, based upon the overall circumstances, finds that the rehabilitative potential to really be largely irrelevant in this situation. There were aggravating circumstances, and some of them were articulated by Mr. Sladauer, and certainly an aggravating circumstance in any sort of crime or offense is the death of an individual who really fell into a situation that was no fault of his own. The mitigating circumstances the court must look at include, the court does believe that Mr. Cooper is contrite. He has no criminal history. This is his first brush with the justice system. And further, that he has dedicated his life to helping other people, but those efforts weren't terribly apparent on the night of August 24th. The statutory factors the court must look to are in 18.102.5 of the Colorado Revised Statutes. That's to punish a convicted offender by assuring the imposition of a sentence that's deserved in relation to the seriousness of the offense. Under subsection B of that same statute, it recognizes that part of these goals are to assure the fair and consistent treatment of all convictors, all folks convicted by eliminating unjustified disparity in sentencing and providing fair warning of the nature of the sentence to be imposed and establishing fair procedures for the imposition of sentences. Interestingly, in the court, the Department of Corrections used to, in their yearly reports, kind of have a nice published handout, I suppose, for the legislators so they could figure out what was going on. But I always took a look at it before I imposed a sentence. Unfortunately, they've kind of lumped a whole bunch of offenses together, and it's not much of a help for a judicial officer to try to find sentences in similar situations. I did my best. And in 2023, there were a couple sentences handed out for criminally negligent homicide in the state of Colorado. In Montezuma County, there was a case where it was a gentleman who was hunting and shot and killed another hunter. He was sentenced to 90 days in jail. Another hunter with a bow this time in Garfield County, who was sentenced to 6 months in the county jail. Going back a few decades, and we discussed this case during the trial, Nathan Hall, as I believe his name was, and that was in Summit County. He was an expert skier who was out of control and killed another skier while he had alcohol and marijuana in the system. He was sentenced to 90 days in jail. With, I suppose, some irony, a law enforcement officer, and I'm forgetting his name, it's Eduardo Landeros, was, I don't know if he was a rookie, but he's mighty close to it, a police officer who was responding to a non-emergency call in the evening in a relatively busy neighborhood, going nearly 100 miles an hour with no lights and no siren. That ended in the death of an individual who had nothing to do with the call. Mr. Landeros was sentenced to a year and a half in the Colorado Department of Corrections. The next one is somewhat shocking to the court. And it's, I suppose there are a few parallels, but the situation in this case was a physician, Dr. Kim, who his patient was put under anesthesia for a cosmetic surgery. That patient, who was 18 years of age, became non-responsive, and Dr. Kim instructed his staff for a period of 5 hours not to tell anybody. Eventually, after 5 hours, Dr. Kim figured out somebody better be called so this young woman could be taken to the emergency room, where she lived in a vegetative state for a period of time before she died. Dr. Kim was sentenced for the count of attempted reckless manslaughter, also a Class 5 felony. And I'm sure there are circumstances that the court is unaware of, but Dr. Kim's sentence was 15 days, which, again, I'm sure there were other circumstances that were much different than what the court saw in this case. Under C, to prevent and promote respect for the law by providing effective deterrence to others who are likely to commit similar offenses. And I'll take that into consideration. There's certainly some relevance. To promote rehabilitation by encouraging programs, correctional programs actually, that elicit the voluntary cooperation and participation of convicted offenders. As the court mentioned earlier, the court does not see rehabilitation really as an issue in this case. E, to select a sentence length, and a level of supervision that addresses the offender's individualized or individual characteristics and reduces the potential that the offender will engage in criminal conduct after completing the sentence. Here, looking at the individual characteristics of Mr. Cooper, the court would find that the potential for future criminal conduct is really not a factor the court needs to consider in this case. The next factor, under subsection F, to promote acceptance of responsibility and accountability by offenders and to provide restoration and healing for victims and the community while attempting to reduce recidivism, which again the court does not see as an issue here. But other than recidivism, there are factors in subsection F that the court must weigh and consider in this case. Somewhat unusual after being on the bench for 18 years. Then criminal for at least half or more of that. And being faced with a situation where you have somebody who has really dedicated his life to helping other people, and yet being involved in a case of this nature where a young man died for really no reason. And at least from the courts listening to the numerous experts from both sides who testified in this case, it occurs to the court that it didn't have to happen. It could have turned out much differently. In this case, the court, in weighing all of those factors, is going to impose the following sentence. The court's going to impose a 4-year probationary sentence. As a determined condition of that probationary sentence, Mr. Coop will serve 14 months in a work release program. He will complete 100 hours of useful public service. The court will stay the sentence in this case until June 7th. That should give Mr. Cooper plenty of time to make arrangements that, if possible, he will be able to continue his employment. That's going to be the sentence in the judgment of the court.